Well, thank you, Leo, for that very kind introduction. Really appreciate that. And it's good to be presenting to a group that has added a lot of value to my practice. So thank you for attending today. I know you're all very busy. As Leo mentioned, my background is I'm a business transactional attorney. So I help out business owners on transactional matters, including thinking long-term, particularly when a business starts to do well and it appears to be there for a long time, long-term planning. And that includes planning for when one or any of the owners passes away. And Megan's background is estate planning. So we thought it'd be interesting to do a presentation that blends both the perspective of the business transactional attorney that's doing some of the advanced planning for business owners combined with an estate planning attorney. Particularly, Megan has a niche on planning for digital assets, which is becoming more and more integrated not only in our private lives, but also in our personal lives. And I would just say, it seems going around the room, we have quite a few estate planning attorneys attending today. And we want to make this as interactive as possible, particularly when you have so many people in the audience that are knowledgeable about this area as well. So by all means, you have something to chime in. Other people have questions. Don't hesitate. Don't be shy. If it's just us talking to you for 40 minutes, it's going to be pretty boring. So I'm going to start the presentation by talking about more traditional estate planning tools for business owners. Buy-sell agreements, estate planning, wrinkles that come up when you own a business with estate planning, things that you need to be thinking about. And then Megan's going to present on the overlap of the digital assets in estate planning and how you blend those long-term planning with the digital assets for you and for your business. And so I thought I'd start with buy-sell agreements. You know, what is a buy-sell agreement? In the context of business planning, a buy-sell agreement is essentially you have co-owners in a business and you're planning for future trigger events. What's going to happen when you pass away? What's going to happen if somebody who is an owner of the business becomes permanently disabled? What happens when somebody leaves the business? And if you don't have a good game plan in place for when that happens, well, that's what leads to litigation, which keeps some of you busy, which is great for you, not so great for the business owners. And one of the key aspects of a buy-sell agreement is what happens when someone passes away that's an owner of the business. And it's important to keep in mind that with any estate planning that if you don't do anything, you already have a default game plan in place. It's what's provided by California statutes. And so are you okay with that default game plan, or do you want to put something else in place? And for a lot of business owners, they're not okay with that default game plan. They don't want, they might feel great about their spouse at a holiday party once a year. They may not want to be in business with that spouse, right? So they may want some other types of planning that occurs for when they pass on. And really the biggest things to think about when you're doing a buy-sell agreement for when somebody passes away is that, what is the valuation? When one of the owners passes away, how are you going to value their ownership in the law firm? And on the one hand, you want it to be fair and market because that person has spent a lot of time helping you build up the value in your law practice. On the other hand, if it's too weighty, if it's too much of a valuation, well, that can really cripple and sometimes break a law practice too. And so it's coming up with a valuation mechanism, a game plan in advance about what is a fair valuation for that person who's passed on for their portion of the law firm. The second thing is, well, how are you going to pay for it? So you got this valuation mechanism. Perhaps you have, the game plan might be a business appraiser comes in, appraises the law firm. The game plan might be some sort of equation based on gross receipts coming into the law firm. Okay, you have a number. This is the fair valuation for that person who's passed away. But how are you going to pay for it? Is it going to come out of the proceeds from the law firm? Are you going to get life insurance on each of the partners in the law firm to pay for that purchase price? And so it's thinking about what type of valuation mechanism is going to be fair, both to the law firm, people staying in the law firm, and also the person's family who's passed on. And then lastly, when is it going to be paid? Is it going to be paid within 6 months of the person passing away? Is it going to be a promissory note that's paid out over time? If it's a promissory note paid out over time, what is fair interest rate on that promissory note? What happens if the law firm defaults on the promissory note for paying back the estate? So those are some of the major considerations that go into that portion of the buy-sell agreement. It also covers, as I mentioned, permanent disability when someone leaves the law firm. But in the context of estate planning, it's what's the valuation going to be? How are you going to pay for it? How is it going to be paid out over time? I'd say one of the most popular methods is life insurance. It really depends on the health and the age of the law firm partners about how expensive that's going to be. But if it's a viable solution, it can really work out well for everybody because the heirs, they don't want your portion of the law firm. They don't. They'd much rather get a check, that's often $1 million from a life insurance proceeds. and then the law firm gets the equity back, and it's kind of a nice, clean way for the beneficiaries of the estate to get value from that value that was added from the person, with the law firm also not having to come out of pocket at that time for perhaps a large amount. Please.
Just a quick question. Non-lawyers are not allowed to practice laws. How can you have, and they're not allowed to have an ownership interest in a law firm, I thought. So how do you, it seems like they've got, for them, the value of the law firm is zero because they can't own it. I must be wrong.
Yeah, no. I think it's a good segue to like the next part, like estate planning in the context of a law firm, right? And I think that I think the estate planning attorneys here would say everyone should have an estate plan. That's true. I think it's particularly important for people that have children, real estate. I also think it's particularly true when you have any business, particularly a law firm. And I know when I did my own estate planning, part of that estate planning process was what's going to happen to my firm when I pass on. We all have that same end destination, unfortunately. But what's going to happen to my law firm? And it was designating another attorney to step in and, for all intents and purposes, be the trustee of my law firm while they go out and find a buyer. So I've decided my law firm should be sold when I pass away, hopefully a long time out. That's right. For them to find a buyer, right? So that is part of my estate planning process. Because you're right, like a non-attorney cannot own shares in a professional corporation that's a law firm in California, right? So it's, you can do different variations of that depending on what you want for your practice. My choice was to designate a person to step in, run the law firm, find a buyer at a price that they felt was fair, kind of in that interim, right? But I think it's always important, particularly in the context of law firm. You may instead want to have it be an asset that's passed on to people that you practice with at your law firm. You may decide that people that have been with your practice for a long term, that they should get the equity. You don't want to sell the equity, right? But I think the long story short, really what's important is that the estate planning process in California, if you don't do that advanced planning, again, you have a default plan. You got the statutes in California. You end up in probate, which is expensive and takes years. So you want to think ahead. And as part of thinking ahead, you don't want to use an off-the-shelf estate plan, online platforms. Ideally, you want to work with an attorney that's helped other attorneys plan for what happens not only to their home, who gets custody of their children, but also what happens to their law firm practice when they pass on. Because it is an additional wrinkle that's not properly planned for, can really create a mess when you're no longer here. And I think with any estate planning, and planning for your law practice is no exclusion, it's really about the people that are there after you're gone. And so it's not fun to think about this stuff. It's not fun to plan for this stuff. But if you don't have a plan for your law firm for when you pass on, what about your clients? What's going to, the day after, and they're sending emails into you, who's going to be responding to those emails? What's going to happen to those projects? And there's no one there to pick up the ball. One, they're going to be hurt, and then your family may not get as much value from that asset.
I'm just wondering, there are a lot of estate planning lawyers in the room. I haven't worked with a small practice. Have any of you guys done this work? Have you helped solos or just one or two partners? Has anyone done the work? Because I want my plan redone. Yeah, you have?
Yeah, just for close friends. Only for close friends. I'm not advertising it, but I'm working towards getting to know it better. Yeah.
So that's kind of an overview, the two things I think about from a business lawyer perspective in terms of buy-sell agreement for the business owners, estate planning as a law firm business owner. And from there, I'd like to have Megan take the wand and talk about the digital overlap in this larger context.
Thank you. The gatekeeper here. So as a segue from that question, I actually have talked to a number of people, small firms, about kind of the estate planning and what happens, because I bought a retiring attorney's practice, and he sold me his practice early because he actually had to administer his two best friends' practices when they died 2 years apart, right before he sold the practice to me. So I know a little bit from just experience and talking to him, and I've tried to share the wealth of knowledge, and we're working on it. I guess I am taking applications. I have a group of small office attorneys that we want to sit down and do our small office estate plans over martinis. So if anyone wants to join that group, I think we'll be launching in the fall to brainstorm the best way to do that. A bunch of small solo practitioners figuring out the right thing. So that's where this is. Let's see which direction we're going. Digital assets. This is a fun definition that they added to the California Probate Code. Does anyone, I just take a show of hands, who owns a digital asset by this? Who is a financial planner in here who is concerned with the definition that it might include all the money in the world? We've got one in the back. Financial planners hate this definition. Overly broad. Also, does this give any sense of what we're talking about to people?
Can you hold it in your hand?
Well, maybe. Is my computer a digital asset by this definition?
I think so.
Right. And so is all money, because, the asset or liability is itself an electronic record. It's not helpful is the point. So what do I say? I have a digital asset definition on my blog that is literally, we tried to get it as short as we could, a definition. We worked with a linguist, someone who has a master's degree in linguistics, and her husband works in the tech industry. We ended up with a page-long definition. And it starts out with, a digital asset is something that you own or that you license and you access it, and it has some value for you, and it just goes on for paragraphs and paragraphs, and that's what we got. This is what the law says. I say it is, for my purposes, I don't include all the money in the world. I don't look at anything that is regulated through other means, if that makes sense to anyone. So the financial world has some great regulations. I think we should follow the financial regulations instead of try to follow the digital asset probate code to grab money and transfer it to other people. When I think about digital assets, I think about definitionally emails. I think about marketing lists. I think about data that's stored in the cloud. Anyone else want to add something to here to clarify what we're talking about as we move forward? Anyone else? Social media, absolutely. Followers, the value of your social media, right?
Well, the goodwill in your business is somewhat wrapped up in social media.
Right.
So you have to parse that out apart from the rest of the goodwill.
Absolutely, yeah. And then we go to intellectual property, right? We have an intellectual property and an interest in everything we put online, right? If you take a photo, you have a copyright interest in that if you post it online. Anything you write, a blog post, an email, all of your content on your website, you have an intellectual property interest in that. So, and then we have blockchain. We have one person here that was sharing a little bit about what's on blockchain. Some people say those are the only true digital assets. I'm going to say it's a little bit broader than that. So now that it's clear as mud, let's move forward. Laws that affect digital assets post-death. We have the probate code with the uniform law there. Contract law, what do all of these things have in common, right? They have a third-party company that's holding them. So we have terms of service for Facebook, for Google. We have privacy policies, inactivity policies, and escheat policies. Has everyone read these for all of their digital assets?
Cover to cover.
Cover to cover, right? A lot of people in this city write these, right? We don't have them here, but this is one of the most fascinating things I find. I either teach this issue to a group of people who's primarily estate planners, or I teach this topic to a group of people who are primarily tech attorneys. The tech attorneys are all like, oh yeah, we know terms of service, we know privacy policies, and you ask, who has an estate plan? Who's read the whole thing cover to cover? And they go, not me. I talk to the estate planners, and I say, who's read the terms of service? They go, not me. But they, we know trust backwards and forwards. So we have simply contract law. You have your Facebook posts. You have all of the photos you hold in your Google or Amazon cloud storage. What's the main law there? It's the contract. Right? Is everyone clear on that? So that's the first thing. So if you want to know if you own this asset, if you can access it post-death, if you can transfer the ability to access it post-death, you have to read the contract. That's not very fun. I usually have to assign my law school students 3 weeks for them to believe that I want them to read terms of service and not a case for this class when I teach it. So no one wants to read terms of service. It's a joke. Privacy policies are usually a secondary policy that is not in the terms of service page. It's usually somewhere else on the website, but again, it will talk about who the company can release your account data to. And so this will say whether they'll release it post-death. Who can they release it to? Inactivity policies, it's exactly what it sounds like. If you are not active on the account, what happens to your data? Has anyone gone inactive or had an account kind of disappear when they haven't used it for a while? Yeah, you've had that happen. So that's another thing. So we don't have data, we don't have data policies. Again, it's all contractual company by company. So if you don't log into a bank account, what happens? We have unclaimed property. It goes to the state. They notify you, that sort of thing. That's an escheat policy. We don't have that with data. So if you don't log into an account that holds data or photos or music or anything like that for a while, they might just close it down because you're a cost center for them if you're not logging on. So all of this is going to be in the contract law. Then we have communications privacy law. We have both federal and state communications privacy law. That's going to be our emails, our text messages, any sort of private messages. Anti-hacking law, we're not going to go into that, but we have some criminal defense attorneys who might be familiar. And then as I was talking about, the intellectual property law, which has kind of built the internet. So when you're talking about digital assets, we just have a few areas of things that we have to review to decide if you own it, if you access it, if your estate has an interest in it. So here's the federal law. This is the communications privacy law. ECPA, has anyone heard about this? Yep, really popular. Practice area in San Francisco, less so in other parts of the country. Anyone want to take a stab on what is an electronic communication and what is not an electronic communication? This is a whole area of debated law. So the idea of email is a private communication. So it is highly protected under federal law. How many people have multiple email addresses, more than one in the room? How many people have that in their will so it's clear who's allowed to access it? How many in their trust? How many in their business succession plan so it's clear that, as Doug said, when the client emails are coming in the day after you die, or maybe you're not even dead yet, maybe you're just in the hospital, who's allowed to get to that? Federal law says Google can't release it to anyone. It's protected the same way a text message is, any sort of private communication. Google has liability to the third parties who might challenge that. And we have ethical duties as attorneys, right? Should we be letting our spouses get to our business emails? Or do we have liability from the clients if our spouse reads a protected, privileged communication? The federal government also protects that. That would be a private communication. By definition, a private message on Facebook, Twitter, something like that. Our emails, text messages, they're all protected by different portions of ECPA. That's different than a blog post, something public facing, right? Is everyone clear on that? Okay. So this gets us to California's new law. It's the revised Uniform Fiduciary Access to Digital Assets Act. It doesn't do a whole lot. I'm not a big fan, but this is what the Uniform Code came to. It encourages tech companies to create in-app tools. Anyone have a guess which tech companies have in-app tools? Who in the valley is big enough to create an in-app tool to transfer things when you die? Facebook, yes. What was the second one? Google. That's it. They're the only ones who've created anything. Everyone else has things like inactivity policies. This is a cost center for tech companies, and so they aren't interested in doing it. So they encourage them to do that, and it provides a framework for fiduciaries and tech companies to sort out who gets access. It really sets up a way for fiduciaries to talk about it. What's the problem here? Is a tech company ever going to release something if they have liability under federal law? No, they're not going to do it. They could get a probate order. How compelling is a California probate order to an international company if they might be in violation of federal law? Yes, not at all. They just ignore it. So that's what we're seeing. So they can sort it out. They can talk about it. I believe there might be arguments for public assets if they are directly written into a will. I don't think that the tech companies are going to do much with a probate order where it's not clear. And when I talk about something that's directly drafted into a will, if I say all my digital assets go to my husband, Timothy, what are my digital assets? Do we follow the the definition in the probate code. How do you know which Gmail address I meant? Is it meganelliop@gmail.com? Or is it megan@meganelliop.com, which is also on the Google server? Or is it, doglover32@gmail.com? So even if you have something that you might get, you have something broad written into a will or a trust, you're setting yourself up for a lot of work post-death. This isn't a sending the will to Google and having them turn around. We're talking about affidavits to the probate court to prove that meganelliop@gmail.com belongs to my husband Timothy so that he can access this. So, any questions there? Keep going. Yeah.
So what happens with the history of these emails? I understand that it's the right to take over the interactions of the accounts afterwards, but is there any kind of law or regulation around having the backups of those emails just be available and that's it?
Somewhat. And company by company, some of them are more, they're changing their policies regularly. We have some cases that have been happening for a while. I haven't checked it recently. Microsoft would give you a CD of all of the emails that were so old. Some companies will provide data from the emails, so they won't provide the body of the email, but they'll provide the to, from, and the subject so that you might know who the deceased person was communicating with, and they'll provide that through a download tool, and hopefully that will help you administer the estate. But right now, things are moving a lot. There's a lot of federal liability for releasing something, even if my side of the communication of an email does belong to my law firm or my husband. What about all the people who emailed me with private communication? They can still sue Google. They can still sue Microsoft for releasing it post-death.
So I've heard of people doing something like submitting their password to like an estate planning attorney, and so that upon the death that gets opened up, and that's how they, at least for de facto, it may not be de jure, transfer of ownership. So at least they can, go in there and, I don't know, get the data out. Do you have any thoughts about that? I mean, I don't know how legal it is, but it's,
Yeah, no.
Like a key, giving a key.
Right, absolutely. So it's a good question. It's something that a lot of people are doing. A lot of people are even giving the advice, leave a list of all your passwords. Leave it in the estate plan file. As a lawyer, I would never collect a list of passwords. I do not want that in my file at my law office. I think the other thing of concern is it breaks almost every terms of service contract law to share your password. And I don't think that's necessarily a problem until you're like, I'm just gonna go clean things up. So let's kill off Doug because he agreed to be my partner in crime today in the presentation. So Doug dies. He leaves with me the list of passwords because hypothetically I'm the trustee that's supposed to run his law firm for however long. And in that list, let's say he left me, one of your hobby account passwords that, related some family things. And I was like, I'm gonna do the right thing. I'm gonna log in, notify some of his friends and family, and I'm gonna hand it over to his wife. So I log in, I do all of this, and then there's some sort of glitch. There's a push, maybe his wife is logging in at home on an iPad or something, and we have this conflict, we both get locked out. Well then, being the good digital asset attorney I am, I would have to go to the company and say, doglover@gmail.com was my buddy's dog's, I'm his trustee, I clearly have power to take care of it. And they'd say, great, when was his date of death? And you'd give it in the day of the death. And they'd say, what about all of these logins since date of death? And then you have to explain that. And that's fraudulent access. And if that's fraudulent access and it's a terms of service violation, you've lost all your negotiating power. Because tech companies just ignore you when you have terms of service violations. And so by creating this, tech companies aren't correcting anyone that says just share all your passwords because it gives them the upper hand. Because you're violating terms by logging in without permission. And maybe I would get some anti-hacking coverage with the fact that Doug said Megan Yip is my trustee and should be allowed to access my assets, and I've left her my password. Maybe I'd have some anti-hacking coverage, but I wouldn't necessarily have, permission to just ignore the terms of service. If his email was under a non-transferable license to access the account, I can't just say, well, I didn't realize that. Sorry. They could do whatever they wanted. So I think it's just not foolproof. And I worry about people accessing and then running into these problems. I mean, you should really air out the problems and then look for access and transfer, or data and transfer. Yeah, go ahead.
Can one take care of this ahead of time, saying, here is my little black book of all my IDs and passwords, and I give this one person permission, should something happen to me, and would that avoid the...
I don't think so, no. I think the in-app selection through Google and Facebook is good, but I think that unless you have like a really clean life and no one's going to fight over anything you access, it's going to be hard. I think it's fine, like in the rose-colored, look, everyone in your law firm gets along, everyone in your family gets along, no one's going to have any problems. Sure, then, whoever finds that list of passwords and usernames should just go to town and do that until they access the bank account that was obviously your brother's, not your sister's, or, the PayPal account, which was your side hustle, where all the money was going to go to your nephew that helped you set up the side hustle. I mean, none of it's clear, right? I mean, am I making this up? Does anyone have one person in their life that should have all their passwords and usernames? Show of hands. Maybe, I mean, maybe. I don't know. I think being a lawyer, it makes it harder because,
You gotta marry another lawyer, and then it's much cleaner.
Well, that's the solution, huh?
I was going to say, I'm married to a lawyer. He will not touch the practice. He's like, that is not my kind of law. So he does not want the usernames and passwords. And then there's the question of where do you store your usernames and passwords? Little black book might be right, but if you're resetting, how often? And then a lot of people say, how long are passwords around?
You pay for a password manager.
Yep.
And then that way you give the keys to that as you update.
Right. How does everyone feel about password managers? Everyone uses them?
What's that?
You want to explain password managers? It's an important part of the presentation.
So it's just a service that you pay for, and it's highly encrypted, and you put your username and password to each website, and if you have it open, then it'll remember that. It'll generate a password that's like 27 digits, letters and numbers and things that it's very hard to hack. And then it'll automatically save it for you, and then you have one password that is really complicated that you know that you can log into it. You don't tell anybody except for one person who's got it locked somewhere, that, that kind of thing. And then you have your one master key, and then it's a key to everything else.
Yeah.
And it's not very expensive, and it's pretty easy to use.
Yeah, another comment on password managers?
Yeah, LastPass in particular is one of the password managers that has the emergency access feature where you can authorize another LastPass account to request access to the entirety of the vault.
That's right, and that's a really cool feature. It's been around for about 2 years, I think. I don't know if anyone's jumped on board, and again, there's some questions because you're encouraging people to break most terms of service, but it is a necessity because most tech companies have terrible customer service for post-death. I don't know if we have a fiduciary there smiling about that. If you try to get access to an incapacitated person's any online account, the legal and upright way, you will be, I'm sure we have some stories there.
Keep some subscription on Amazon after he died. I became a Fiduciary about 9 months after he passed. And cancel the numbers. Awesome.
Yeah, it's really hard. Yeah, another question or comment?
Is there any statute of limitation on this? And ultimately, your passwords are sheet to the state. What happens?
Passwords don't escheat nothing. Data doesn't escheat. This is really interesting. Like on the theoretical level, all of our data when we die is allowed to stay in private third-party company hands. Isn't that weird? That's the first time in human history.
I'm a little confused. You're saying that the terms of service would, in a sense, override state law, because if you transfer your assets to someone else, and you're very specific and clear about it, I don't see how the tech companies can say that it's a violation of the terms of service. Is there case law on this that's saying that yes, it is? Because it seems to me, if I give Doug, Doug's my brother, I give him access to everything in the event that I die. If I can transfer land that way, I can transfer cash. Why can't I transfer a digital asset?
Well, let's talk something more akin to a car lease or a small storage area or something like that. Let's think about non-transferable license to access. So you don't necessarily have an ownership right in the majority of the digital assets you and your business depend on. So you do not necessarily have an ownership right in most of the digital assets that you and your business depend on. You have a non-transferable license to access the storage or the presentation method.
Well, that seems to me that seems to me to be itself an asset, though. Still, even though it's the terms of service calls it non-transferable. Is there any case law on this?
Any case law on the terms of service being more valuable than state law, but then we have federal law for the majority of the assets, because what's a private communication under federal privacy law that says you can't release it? So is transmitting a photo to you on Dropbox, maybe it's for a personal injury case, is that transmission a private communication? Saying, I'm going to share it with this personal injury lawyer so that the estate can be represented by you. Who should have access to that photo?
Well, whoever has the rights to step into that person's shoes. I mean, that's the whole idea of this law, is that we want to spread our power around to people we trust. And there's got to be a way to do this. It seems counterintuitive. I know the law is often counterintuitive.
Right.
It seems counterintuitive that in this area you cannot let someone step into your own shoes.
Yeah. You can't.
It's a private company, and that deceased person had a contract with them, and it's not transferable. Even though your business is running on it, it doesn't make sense. Yeah.
But see, it's not a transfer. They're you. They're an alter ego for you. You are me. I'm you.
Right, but that client that you had a communication with on your email has a right to privacy under federal law, and so then you can't.
But not from someone who's my proxy or my attorney.
Yeah.
Except for, could they argue it? I mean, and this is what Google's going to say. I'm not going to get in the middle of that.
Well, and that's what I'm
Right,
asking, if there's any case law on it.
No, because they won't even touch it.
Yeah, they just let a mess. It's good to be king.
Yeah, I mean, Google, who's going to fight Google on federal privacy law or on who's standing in whose shoes?
Eventually, someone whose estate is worth it, whose digital assets are worth it.
So we have to start drafting them into all of our plans and succession plans, because right now the cases that are coming forward are, well, I'm the son, I'm the mom.
Right.
That's a bad case. I'm the mom, I don't know what's in my son's computer, I should obviously know. Go ahead. What do you mean? I'm going to get your apartment, I'm going to get your bank accounts. Why don't I get what's in your computer, son? No, what's different about it? Tell me. Right, there's something there, right? What is it? So anyways, let's move on to technology and society. Maybe we'll answer and air some of these things out. I don't think anyone has a problem with this, technology and society. These are all numbers from Pew Research. Everyone's using it, right? Like everyone is using digital assets in our business and our personal life. This is just a scale that I like to use. Some people say, oh, it doesn't affect my clients. I go to estate planning things. It doesn't affect my clients. Estate planning attorneys in the Bay Area, they think it's novel. I'm a niche practice. No, everyone owns something of value that we don't know how it's going to transfer post-death. It's a normal thing. This is an interesting thing. Why are people not doing estate planning in digital assets? This is my theory, digital literacy. Financial planners, what does this look like? Financial literacy. People who are living paycheck to paycheck don't have estate plans. People who are using their technology in a way where they reset their passwords every month or they change where they're storing things every month don't have long-term investment in the technology they're using. They don't have to do digital asset estate planning. The people I help with for digital asset estate plans are people who are choosing their technology very specifically to actually make their life better over a term of months and years. And so when we talk about that you're strategically organizing where you store things, how you access things, how you retrieve things, that's digital asset management. That's actually a practice that you have to, work into your life, the same way you work in financial planning. And so you need an IT guy. You really need to think about this. I think it's actually detrimental to your life and business to be on lots of different platforms. Not just because of your estate planning, you're not effective that way. If you want to make your life better, week over week, month over month, you have to have better digital asset practices. And then we'll get to a place where you actually have 5 or 10 companies that you can really prioritize. You have all your data in one place. You have all your communication going through one system. And then we can prioritize and do an estate plan about who should get what. It's really hard to do an estate plan for someone who can't put together a digital asset inventory because they are on every service. Right? Can everyone feel that? One more question and then I'm going to rush through the rest of my slides.
Yeah, so I know that this actually touches on a lot of reasons why I usually help clients consolidate services when they're spread out over Dropbox and Google Drive and OneDrive.
Right.
But when looking at this, it also brings the question of when you have tools that the data, the master data is stored on their servers, but when you have sync kind of software, you have Outlook that downloads a copy of your Gmail, you have Dropbox that syncs down to your hard drive. You walk away with that copy on your hard drive on that computer. Does that skip over the legal concerns in that sphere?
Yeah, in a lot of ways. Things that you download, things that you print, those aren't digital assets in the sense that they aren't held by, as he eloquently put it, a third company. You're backing it up. So a lot of this is also, once we have you doing better digital asset management and future planning, then we can go through and say, do you need a technological solution or do you need a legal solution? And how do we do both? And I like to work with IT people who can help us do that. Because the answer for photos most of the time, what are the photos that last? What are they, what medium? Thank you, paper. What's the best way to save your photos long term? Print them. There's your legal advice for the day. Sign up for Facebook, sign up for Google, print your photos. We've come full circle. Here's another big picture concept. We can do this by a show of hands. How many people think the internet and that technology is about privacy and anonymity? You laugh, but I go to rooms in the Bay Area and teach this, and they know for sure that's why we invented the internet. It's only been the last 5 to 10 years that we have people that say, no, the internet is about intentionally leaking things. But the people who created the laws, the people who created the system said, the internet's amazing because you have private anonymous communication. What? No, I mean, it was in the 80s. We could have those folks come and talk. They drafted these laws with that assumption.
I did see on Facebook somebody posted it's forgive me, Father, I have sinned. And he says, I know, I saw it on Facebook.
So we've already talked about these, and thanks to that we can move along. But these are two things that are very hard, and we already talked about why they're difficult. Passwords I say a list of passwords is too much and not enough. It's too tempting to log into things you aren't supposed to. And what is a list of passwords missing? Your wishes and desires. There's nowhere on a list of usernames and passwords that says, delete this. I mean, and deleting things is the easiest. That's one of the great things about digital assets. So another easy thing you can do is make a list of all the accounts you want deleted. Don't leave it up to someone to find out there's nothing there or there's embarrassing things there. So this is the estate planning process. It's not that difficult. I've already shared most of it. Inventorying, password managers help with it. Download a list without the passwords. Put your wishes in there. Delete. Business asset, spouse, what do you want to have done? Consider the law. Yes, read the terms of service. Ownership interests. I mean, maybe reviewing the terms of service, what does that mean? Maybe you want to get off that platform. I mean, honestly, that's sometimes the best advice I can give for someone. I have a street photographer in San Francisco. He's storing somewhere because he likes the way it's organized. If he wants to store it for longevity, we're just going to move all the photos to a different, a different service so that he can have one for access and one backed up for longevity and for transfer to his kids. It's not a hard fix. And then consider technology. Work a lot with IT guys. And what do I need to make sure? Just the same way I work with financial planners, I need to make sure the tech is set up and stays set up the right way so that my estate plan works. The same way you have to make sure the financial assets are titled correctly. They need to let me know if they move things. Are we encrypted? Are we backed up? Are we on duplicate servers? All right, and then succession planning. Know the policies that affect your tools in your company. Balance security with redundancy. Yes, it needs to be private, but we need multiple people looking at this. And then include digital assets in your documents. Buy-sell agreement that leaves out the marketing list a week before Christmas, that's not going to do much good. If no one knows about what's for sale for Christmas, you're going to miss a huge season. And I want to note, we're all small business owners, you don't have to do this yourself, delegate it. Get someone on your team to be the digital asset expert. So I know I'm running out. I'm sorry. Okay, good. There's one more in the back.
Oh, yeah, I was going to say, there's certain websites that, whether they are HR related or even sometimes just shopping related, that you do not have an option to delete your account. I've run across those in the past. Is there any functional difference upon death where you can actually approach them with appropriate documentation to force the issue, or does it still forever stay there?
I mean, and this is something you could probably opine better than me. If someone tells me they delete it, what are the chances that it's actually deleted? I mean, I think there's a lot of companies, depending on who you talk about it, Facebook, they're swearing right now that if you ask to be deleted on death, that you're deleted from every Facebook server ever. Most people are like, no, they can't promise that. That's not how this technology works. So, I mean, I think they can hide you. I think they can put you in a different algorithm set. But you would know better than me, is anything ever really deleted?
Depends on who you ask, the clean room expert or the access expert.
Right. Absolutely. Any other questions for Doug or myself for how it works for business?
Password manager you recommend or like?
I mean, Consumer Reports does great reviews on password managers, so I think it really depends on what you're looking for and your business needs. I'm on 1Password. I really like it, and their new feature is that I can provide a 1Password account for my paralegal, and she puts all her business ones in there. We put our shared ones that belong to the company in there, and then it also gets her personal passwords. So it's like a 3-tier. We have here's things that as an attorney I should only access. Here's, like e-file. We have one account, but everyone in the office should be able to access it, and it belongs to the law firm. And then her personal stuff that I care about her because I want her to be protected. She has a vault for that, and I really like that. 1Password.
You and I can talk later.
Yeah. Dashlane's great. LastPass. I mean, yeah.
Great. Well, thank you so much.
Yeah.
Megan and Doug.
Thank you.
You're welcome.